welcome back to the Elder Law Out Loud podcast. I'm Karla Ray here with the CEO and founding attorney of Family First Firm, Geoff Hoatson, and today we are talking about real estate and how different real estate transactions can impact either your estate or long-term care planning. For most people, Geoff, their home is their biggest investment. Many people never even get the chance to own a home. So for those who do, they want to do whatever they can to protect this asset. And a lot of times it's what people plan to pass down to their kids. Talk about the different ways on the estate planning side that we can protect that piece of property. And in Florida, lots of protections in terms of the homestead protection.
Sure. So, when we talk about protection, first off, there's a few things we're talking about. One could be protection from creditors, things of that nature. We could be talking about protection from probate, protection from long-term care, recapture, what we call the Medicaid asset recovery program. So there's a number of different ways that we could talk about protection. I guess talking about the first and probably the thing that people think most about when we talk about protecting is from creditors and things of that nature. Fortunately, we live in Florida, and in Florida, we have unlimited homestead protection from creditors, meaning you could have a $20 million house, and as long as it meets certain Florida Constitution criteria, it's going to be exempt of any creditor claims. You could owe $100 million to somebody that can never come touch your house. This is why in a lot of cases, sports stars, sometimes people who are committing fraud and scams and things of that nature will have a large homestead in Florida because generally it's protected from all creditors. Now, obviously, there are some creditors like the federal government who don't really care about what our Florida homestead laws say. And, they will kind of act in a way that ignores, some of the protections that we have. But in general, our state constitution actually gives us protection from any sort of creditors. Then, people worry about protecting it from probate. And so, we use trusts, special types of deeds to go about doing that. Making sure that things pass quickly, easily, in the most tax efficient way possible. Yeah. And then obviously the last piece with the Medicaid, as long as your property is homestead or is owned by trust or something like that, like we talked about, and avoids probate, there really should be no opportunity for Medicaid to come up after.
A lot of times people, when they hear, what goes into setting up a trust and some of the costs involved, they say, well, I'm just going to add my kids to the deed.
Right.
And there are a couple different ways that you can do that. Talk about the different vehicles that can be used to add someone to a deed and the pros and cons.
Sure. So the most common thing that we see is people use like a quitclaim deed or warranty deed. These are deeds where it says, hey, I'm giving my child either a portion of my property, maybe the entire property, maybe it's a quitclaim deed with something called joint tenants with right of survivorship, meaning that you guys both own it, and when one of you passes away, the survivor owns it. So they think, oh, this is a great way to add my kid to the deed. I still have my name on the property while I'm alive, and then I pass away and the kid gets it. The problem is when we use those type of deeds or those, whether it's just adding them as a joint tenant or giving it to them outright, they take what's called your tax basis in that deed. And this can get a little complicated, so I'm going to try to keep it as high level or surface level as possible. But essentially, when you buy a piece of property, you pay a certain amount for it. Let's call it $200,000. And then over time, it's Florida, so that property just continues to climb and climb in terms of value. And at some point then, if you go to sell it, there could be a capital gains, like a long-term capital gains event. Now, normally, if it's your homestead, you're entitled to $250,000 of appreciation without having to pay tax on it. That's great. But if you owned a property for a long period of time, maybe you plan on passing away without selling it. Maybe you pay $200,000 for it, and now it's worth $700 because it's in Winter Park, and even though it was a small little place, the property values are so extensive here now. Something like that. The problem that you have is if your child were to inherit it through either a type of deed we'll talk about later, or will or trust. They're treated as having paid the fair market value when you pass away. But if you added them as a joint tenant with right of survivorship or you gift it to them, they take your tax base above the initial $200,000 that you paid for it. And then if they ever decide to sell it, they have to pay capital gains tax on the difference. So if the property's worth 700 when they sell it, they're going to have capital gains tax on $500,000 in that example. From the 200 to the 700, there's $500,000 of capital gains, being paid at approximately anywhere from 15 to up to 20% taxes. So 15% taxes on $500,000 is $75,000. So people think, oh, I'm saving my kids what would probably amount to like a 6 to 8 month probate, and maybe $3,000 to $5,000 in probate fees, and instead they subjected their child to now $75,000 tax.
Whoopsie.
Yeah, whoopsie. And well intentioned for sure. People don't want to go through probate. I get it, but I also don't think most people want to write a $75,000 check to the federal government if they don't have to.
Right. And so when would a quitclaim deed be appropriate? When would it be a good time to use that tool?
So oftentimes, yeah,
She asks an estate planning attorney.
Yeah, no. So it becomes very fact specific. Oftentimes we use quitclaim deeds, warranty deeds, things like that, where you're actually just gifting it to somebody else or transferring it to somebody else as part of a sale. So maybe if a child were to be purchasing it from you, maybe it's a Medicaid planning tool, and we are paying the child with this house, because it makes more sense to do that than using other strategies. We might pay the child with the house under like a personal service contract or something like that. And we would use a quitclaim deed here, transfer it to you. But generally speaking, if you're planning on gifting or giving something to your children as far as an inheritance, it almost universally makes more sense to do this through either like a different type of deed, like a ladybird deed, or using like a trust or a will.
Okay. We've talked about this on the show before, but explain again the concept of an enhanced life estate deed, a ladybird deed.
Yeah. So those are two terms for the same, I guess the same tool. A lot of people use the term ladybird deed. The actual legal term for it is that enhanced life estate deed, as you mentioned. Basically, so I'm going to start and kind of explain what a life estate deed is, and then what enhancing it does and how it makes it better. So a life estate deed there's basically two parts of the deed. There's the person who's allowed to live there during their life, and that's called the life tenant. And then there's the people who get it after that life tenant passes away, and those are called the remainderment. They get the remainder, right? So what a lot of people will do is they will say, hey, this is my property. I'm going to be the life tenant. I want to be able to live here and stay here. I don't want my kids to kick me out. And then when I pass away, my kids then will get the property. So we add them as the life tenant. Now, the problem is if you ever want to sell the property, if you want to get a mortgage or reverse mortgage or anything that you need to do, you actually need the consent of all the life tenants as well. So maybe you got 5 kids, you've named them all as life tenants. Now all of a sudden you have 6 people that have to be involved to sign all these documents and things of that nature. It can become difficult to get 6 people to agree anything, but even then, practically getting everybody to do this can be a bit of a challenge.
And relationships change.
Absolutely.
We've seen many families come in here who have, estrangements, and that can happen after some of these things are put in place.
Absolutely.
And that becomes even more complicated.
It's a challenge for sure. When we make that life estate deed that operates the exact same way, we enhance it. The enhancement basically says that the life tenant has the ability, and they retain the sole right to sell the property, gift the property, mortgage the property, do whatever they want to while they're alive. It really makes it more like almost like a transfer on death or a beneficiary for the property. In the sense that if I had a bank account and I named you as the transfer on death beneficiary, you don't have rights to it while I'm alive. You're entitled to whatever's left after I pass away.
You're going to catch me out in the parking lot with stop sticks or something.
But the point is, like, you don't know how much is going to be in there. There could be a lot, there could be nothing. Yeah. Whatever it is you're entitled to. But there might not be anything. And that's essentially what this deed says is, hey, if there's a property there, you get it, remainderman. If there isn't, oh well. You have no say over that. So it's a way that allows the life tenant to basically keep control of their property, have it go to their children without needing probate, and has the benefit of that step up in tax basis like we were talking about previously, where in the example from the 200 to 700, well, let's say it's worth 700 when you pass away. Now your kids are treated as having paid $700,000 for that property. So if they turn around and sell it immediately, there's no taxes. They've saved $75,000 by using this tool.
Okay. That tool is great, and it's most times a given that you need, at minimum, a ladybird deed on your property. That's something that anybody who comes through our doors, we're gonna explain to them what you just did. The better tool is a trust.
Sure.
When is a ladybird deed not sufficient?
So, I mean, I think it's probably easier to just talk about the circumstances that can pop up. There are a lot of ways that ladybird deeds can fail. And when I say fail, it's not that they wouldn't transfer, but as an example, you may have two children that you name as the beneficiaries on that deed, and then maybe they have minor children. God forbid one of them passes away with that ladybird deed. It's their share is not going to go to their child; it's going to go to the survivor. So now you've effectively cut off one half of the family from an inheritance that most people would say, hey, I don't have to go to this son and have to go to this daughter and stay with their bloodlines, rather than just all going over to the son if the daughter were to pass away, and as an example. So, the ladybird deed isn't going to do that. If you have a beneficiary on that deed who's receiving government benefits or, is going through a divorce or things of that nature, there's really no protection for them. And so half your house might be going to their soon-to-be ex-spouse through a divorce.
Because the marital asset at that point.
It could be. It really depends, and so there are a lot of generally inheritances are not. However, if you commingle things, which a lot of married people do, all of a sudden it becomes marital. So as an example, that house is sold, half the money goes to the child they put in their joint bank account, and then 2 days later their spouse files for divorce. Guess what? It's marital. And so half of that money is now going to their spouse. So, there's, or their ex-spouse. So unfortunately, there are a number of ways, if there's creditors out there that maybe your child owes money to, they were in a car accident, get sued, those funds could go then to a creditor and that property could go to a creditor. So, oftentimes the ladybird deed is a nice tool for people who are, I would say, I hate to say this, but, kind of like close to passing, or we're using a ladybird deed to have it go from somebody to their trust after they pass away. Those are the places where I really like ladybird deeds. If you have a lot of time left before you expect to pass away, ladybird deeds might not be the best tool because there's just a lot that can change in your life. Believe it or not, I don't agree with this. And there's a lot of argument in between lawyers about this particular thing, but a child who's a remainder beneficiary on a ladybird deed, there is a belief out there by title companies that if that child were to predecease before the person who owns it, the lifetime, that you actually have to probate their portion of the life estate deed, which I don't agree with at all, but there are title companies that absolutely require that, and lawyers are split on this. I see lawyers arguing for it. I think they're wrong, but ultimately, it can be from a practical perspective that has to be done sometimes. So there certainly can be downsides to ladybird deeds. And that's why I say if there's a lot of life expectancy, a lot of potential changes, it's a tool that may not be the best.
So in a situation like that, where the child predeceases the parent, is there any other tool that can be added to the ladybird deed to basically deed it back?
So that's where I really like trusts.
Okay.
That's why, because unfortunately there are limitations on how complicated we can get with the deeds, and we can put language in there. But if a title company doesn't recognize it, or the county says, "Hey, we don't believe that this is valid," you still end up back in the same situation. So, in those cases, in most cases, I think it is better to have a property going from somebody through a ladybird deed to their trust, because the trust never dies, the trust never comes disabled, the trust never is sued by creditors, the trust is never, going through a divorce. Those things continue to exist without any sort of issue. Now the beneficiaries can certainly be going through those things of the beneficiaries of that trust, but we can put language in to protect them. And so that's the neat thing about the trust, is that it accounts for all the what ifs of this world.
All right. So say you've done nothing. You have no ladybird deed. You have no trust. Your heirs are still going to try to get your home after you pass. What do they have to do?
Go through probate. Unfortunately, if you have done nothing, it's going to go through the probate process. I think a lot of people have some misconceptions about what probate looks like. I routinely have people come in and saying, "Hey, I don't want everything to go to the state." It is very, very difficult for your stuff to go to the state in Florida.
Okay.
Basically, they're going to. So everybody has an estate plan. even if you've done nothing. It's in the state statutes. It's called the intestacy laws, and it's basically a statutory will for everybody who's not done any of this. That's probably not what you want, but there's a backup plan for everybody. When I've done seminars, I would say, hey, if you have a estate plan, raise your hand. Like, half of them, a third of them raise their hand. Like, everyone's hand should be raised up because the state of Florida has actually created one for you. Might not be what you want, probably isn't, but it's there. And so if you don't want that, you have to be proactive about deciding what you do want. So the intestacy laws basically say, it's going to go to your spouse if you're married. If you're not, it's going to, well, that assumes you don't have kids from a previous relationship. It gets a little more complicated if you have children from a previous relationship. But for the purpose of this, let's assume you don't. It's going to go to your spouse if you're married. If you're not, it's going to go to your children if you have them. If you don't, it's going to go to your parents. If you don't have them, it's going to go to your siblings. If you don't have them, it's going to go to your grandparents. If they're not alive, then it's going to go to your aunts and uncles. If they're not alive, then your cousins, and so on. And it's just going to branch out through this family tree.
Kind of like,
yeah. Yes. So,
reminds me of like a pinball machine.
yeah.
Like
So it goes, kind of up and then down, and then if there's none of them, then up higher, then down, then up higher, then down. So it really branches out through that family tree, and that's why you hear people get inheritances from uncle I didn't know I had, or someone I haven't talked to. That's how, because that person hasn't done any estate planning. And so then the intestacy statutes just start trying to find family members.
Somebody please take this house.
Yeah, essentially.
So what happens in that time frame if you haven't put any tools in place and you still owe a mortgage? I mean, is it not getting paid during that time?
Yeah, it's not going to be paid. I mean, they might initiate foreclosure proceedings. There's, a myriad of negative things that can happen. There may not be a lot left to inherit, if all those things have happened. So, ultimately, I would say that, that things are not going to be easy. They're probably not going to be what you would want, but ultimately what they are going to do is go to somebody. There is a plan in place. So, like I say, you need to be proactive about making sure that what you want to happen happens, because otherwise that's probably not.
And if you inherit through the probate process, are you having to pay fees to accept that property typically?
Generally not. So the question becomes then, are you the person who is initiating the probate, being the personal representative or executor? In those cases, you're going to be paying an attorney, or an attorney is going to be paid from the estate. Most attorneys won't get started without being paid something to get the case opened. And then they might, depending on what the nature of the assets are, they may agree to be paid out of the estate. That can happen. We do that sometimes. If it's just a property, probably not. We'll probably have to take payment up front. But as far as inheriting, let's say that they're not initiating the proceed, they just happen to be a beneficiary and they're going to get this thing. Generally, there's no fees. The only way that you would see something like that is if they live in a state that has inheritance tax. So we've heard of estate tax. That's if you have an estate over a certain threshold, you have to pay taxes on the amount that you have before you distribute to your beneficiaries. There are a few states that actually have an inheritance tax. So when somebody in that state receives something, they have to pay taxes on it. So there's not a lot of them off the top of my head. I know Pennsylvania, and I want to say New York.
Sucks to not live in Florida.
It tends to be, kind of older states, more northeastern states that have that inheritance tax. And it's not huge in general. Generally, I think it might be anywhere from like 1% to 6% or something like that of what you receive.
Yeah, 6% on $1 million property.
It's a lot of money for sure. But it's not. You hear people talk about estate tax like 40% or 45%. Sure. It's not that. So I will just say that, that there could be a way that you could actually have to pay fees associated with an inheritance if you're living in one of those states that has those taxes.
Okay. So we talked about the estate planning side of protecting property. On the Medicaid planning side, asset protection side, in most cases in Florida, your homestead is considered an exempt asset for the purposes of qualifying for Medicaid.
That's correct.
Except when?
Except when the equity, you're single, and the equity exceeds $765,000.
Okay.
Yeah, and that equity cap changes every year. It increases for inflation as well.
So how do you protect in those cases?
So you can actually do something called equity stripping, where
get a reverse mortgage or something? Really?
So you'll take equity out of the home, and then we'll protect that cash through one of our other asset protection strategies.
That's ridiculous.
It is. It absolutely is.
Okay, so you're telling me my house is worth too much, so I have
Correct.
to take a loan out against my own asset,
Yes.
take that money, move it in a way that's Medicaid compliant, and then
Hmm.
everything's good to go.
That's correct.
That's silly.
Or you could rent it out and turn it into a piece of income producing property if you're not living there.
Okay.
That might be an option. Um, in Florida, rental property is not considered an asset against that asset limit. The income that it produces is considered income against the income limit. So that's also an option. Some people will choose to rent out their primary residence. Um, it's normally not about equity limits, but it certainly can be. And then you don't have to do that equity stripping.
Okay. So talk about the rental aspect of this. How are we able to sort of finagle that in a way that's Medicaid compliant, but also, be mindful about not exceeding the income limits for Medicaid by doing that?
Well, I mean, the first thing I just want to point out is exceeded income is easy to deal with. From being over the income limit, that's an easy solution. We use a qualified income trust or pooled trust to deal with the excess income. That's pretty straightforward. I would always rather have to deal with too much income than too many assets. It's a simpler solution. Um, but that said, when we are doing the rental properties, there are a number of ways that we can discount some of that rental income or have it not countable. So some examples of that will be property management fees. The state will allow you to pay up to 10% of the rental income in a property management fee. If you have a mortgage on the property, they will let you pay the interest. They won't let you pay the principal amount is not allowed to be paid from the rental income, but the interest certainly can be. Um, Taxes, insurance, upkeep, repairs, maintenance, lawn, maintenance, all that sort of stuff, utilities, whatever. All of those things are allowed to be deducted from the rental income if they're being paid. Um, Basically, the Medicaid manual here in Florida is kind of annoying when it comes to this, in the sense that what they say whatever the IRS will let you deduct, that's what we'll let you deduct. And here are some examples of things that the IRS lets you deduct, but there may be more, but go figure it out with them.
Yeah, figure it out yourself. I love that because it's like the IRS does it every year with your taxes too. Like we know exactly how much you owe
Right.
us or we owe you, but we're not going to tell you.
Yeah.
You got to go figure it out yourself.
You got to figure it out. And if you screw
And if
it
you're
up,
wrong,
go
you're
to
going to
jail.
jail.
That's right.
Love that. So great.
Yeah.
So confident when I file my taxes.
Yeah. So that's what makes it fun with DCF as well, is they're just like, well, whatever the IRS lets you deduct, that's what you can
You
deduct
figure
for us
it
too.
out.
Yeah. It's your
Have we ever been challenged on anything like that by DCF?
No, we haven't. We've always, provided all the proof for the previous year of what expenditures have been. It needs to be fair market value.
Sure.
So it couldn't be like $1 million place that they're renting out for $500 a month.
That'd be great.
It would be great, yeah. But the department's gonna have a problem with that.
Yeah. Okay. So that's one way to protect your home if you have too much equity in it. For most people, they're not falling into that sort of scenario. So their home is protected, but they maybe have cash. They have liquid assets. And we can use real estate as a tool in this way too.
Yeah.
Talk about the different ways that we can use real estate.
So that's where you can actually invest in rental real estate, is probably the most commonly known, option. So investing in rental real estate might be something like, there's a couple options here. Either just buying a property and having that rented out. A lot of people don't want to be property managers, don't want to deal with
Especially
that.
if they're going into a nursing home.
Exactly. Or their adult children don't want to deal with it
Right.
either, So what we will see regularly then is, there's an organization out of Ocala who has basically, it was created by an elder law attorney and a real estate attorney recognizing this loophole. They bought a huge portfolio of rental properties and they sell either properties or parts of properties to Medicaid applicants, and then they will guarantee a certain amount of monthly income. And so that's a way of doing the same thing. So the Medicaid applicant owns either a property or maybe pieces of multiple properties, and they're getting a certain amount of monthly income. And so the department then ignores that for the purpose of the asset limit. Now, a strategy that we use with some frequency that I don't see used as often out there is the purchase of a new homestead. If the person who's applying for Medicaid doesn't have a home, because you're allowed to have a home, they don't have a home, sometimes they will purchase a homestead, and that could be either buying their own place or purchasing into the home of a child. And so sometimes, they will purchase a fractional interest in their child's home and then count that as their homestead.
Okay. That last strategy is my favorite one.
Yeah.
So talk about how that works.
Basically just that. So, we would put together, let's say the property's worth $500,000, the child's home, and the applicant has $200,000. We will sell them a 40% interest in their child's home. We will then put together, a deed from their interest, like a ladybird deed, basically saying, hey, when I pass away, this my 40% interest in this property goes back to my child, who I purchased it from. Now these funds are in the child's pocket. They have the ability to use these funds that they need for their parent, and then when their parent passes away, then they're able to distribute those of course with their parents' wishes. The nice thing about it, though, is there's no tax implication associated with that, and the parent has now basically divested themselves of $200,000 that would have made them ineligible for Medicaid. But now the child has it, and they're able to use those and really use it to supplement and give their parent a better level of care.
Yeah. When I explain this to people, they feel like there's got to be a catch.
Mhm.
Is there a catch?
Not so much. I mean, I think the challenge that some people have is they say, well, what if my brother or sister has an issue? Are they going to somehow come and try to, take a part of my house? That's the most common feedback I hear from people concerned, and I would say, well, we use the ladybird deed so that doesn't happen. But, some people still just feel funky about it, or just even feel weird about having mom or dad own a portion of my house. Why? I don't know. I think, family dynamics are complicated. And so, everyone might have different views on that. But as far as the catch itself, yeah, really not. There's nothing there that I really have concerns about we've ever seen go sideways.
Yeah. Only if the primary owners decide to sell while
Sure.
the
Right.
applicant is still alive.
Yeah.
Then it gets a little tricky.
Yeah. So that could be an issue because they are technically a 40% owner of the property at that point, and 40% of any sale proceeds should go to the applicant or that Medicaid recipient at that point.
Okay. Can we just bounce back to the investment group out of Ocala, the Epic Investments? Why didn't we think of this
What do you mean?
to set this up? Because it seems genius.
Oh, it is genius. Yeah. So they set up probably about 20 some years ago now. It's been around for a while.
Okay.
So, I mean, this is I think, I'm trying to think, did they set it up before I was practicing law? I think so.
You were just a little baby
That's
college
it. That's
student.
right. I was probably still in law school at that point. So
20 years ago, you were young and spry and
that's
a little
right.
less gray in the beard.
Hey, okay, we're being a little mean now. I was in law school still. Um, but yeah, so the problem, candidly, that makes it difficult is just the capital. They went out and they bought up a huge portfolio, and they basically just buy back. As a Medicaid applicant will pass away, well, then they buy that property back from them for what they put in. So you're getting the monthly income. The Medicaid applicants getting the monthly income, and then their kids get 100% of what was put in after they pass away. So, having enough capital to buy a huge portfolio of real estate and then having the cash to be able to continue to purchase and, kind of sell and buy that sort of stuff, is just pretty prohibitive.
Yeah. How much do you think they own across the
I
state?
have no clue.
No.
I don't even have a semblance of an idea, to be candid with you.
Okay.
I really don't know. I think it's a very cool model.
Yeah.
I'm thankful that it exists. But
Yeah. It seems like, one of those things that when we explain it to people, it's like just a sense of relief that there are options.
Yeah. Oh, for sure.
Yeah. And of course, you could do that yourself. You could buy your own rental properties, but
course.
that would take a lot more time.
It takes time, and you have to then manage it, and you have to keep somebody in it, and because with Epic, the organization out of Ocala, they will guarantee you that monthly income whether the place is rented or not. So, and obviously it's a net amount, right? They're keeping taxes and insurance and probably a property management fee and, reserve for repairs and things. I'm guessing, they don't clarify all of this. They just say, hey, you invest, I'm going to make up numbers here. You invest $300,000 and we're going to guarantee you $1,500 a month.
And all of your money back at the end of your life.
And all of your money back
Yeah.
at the end. Yeah. So obviously then they have an incentive to get it rented, and they, candidly, they might rent it for a lot more. They may make money. I don't know, from the property management and everything else, but they're guaranteeing you about $1,500 a month because whether it's rented or not, they're going to still continue to pay you.
Yeah. I think it's a great option for families that don't have access to the other strategies that we use on a regular basis. All right, in closing, anything else you want to say just as people are thinking about, setting up their estate plan or long-term care planning when it comes to their home? Any pitfalls, any big mistakes that you see people make?
One of the things that I will just say is, I talk with people regularly. In fact, I spoke with a family yesterday. They were concerned about making sure that their home is always protected in the event that they need Medicaid. And their big concern was, well, if somebody goes in and we downsize, or if that property needs to be sold, then all of a sudden there's an issue with the proceeds of that sale. Well, we know, as you mentioned, that a home within the equity limit, or if you're married, won't be an issue for Medicaid. A lot of times people downsize, or the kids don't have the ability to afford the carrying cost of the house, so it needs to be sold. So frequently we'll put those in irrevocable trusts. Our family fortress is the one we use most common, to ensure that really no matter what happens with that property, that if it needs to be sold or anything like that, that the proceeds will not count against them, that that money is always available and protected. If they need to downsize, the trust can do that and purchase them a smaller home and still have the excess funds available to be used for them.
Mark, you're the guy with all the tools. Thank you so much, and thank you for watching. We will see you guys next time.